All right. Good afternoon, everyone, and thank you so much for joining us. My name is Raylene. I use she, her pronouns, and my role today is to help facilitate our webinar. If you have questions during the presentation, please type your question into the Q&A tab, and the question will get passed to our panelists today. Most of you probably know about our organization already, but for those that listen to this later and those that don't know, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of the trainings that we do are the annual new laws throughout the state of Minnesota, which is coming up, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. It is through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety planning, listening, and helping callers identify possible options and next steps. This webinar, like I mentioned, is being recorded, so you'll be able to check that out on Standpoint's YouTube page in the next couple of days. The link to the recording will also be emailed out to Standpoint's Legal Advocates listserv after the webinar. For today's presentation, I will be putting the link to the PowerPoint in the chat if you'd like to follow along. Next, I would love to introduce our excellent attorney and advocate team here. We have Michelina and Rashawn. They are an attorney advocate team at Standpoint working under the Legal Assistance for Victims grant and assist victims and survivors of sexual violence in and around Ramsey County. Michelina provides guidance, advice, and representation around any issues stemming from sexual violence, including but not limited to protective orders, housing, Title IX, family, employment, privacy, and others. Rashawn helps clients connect with and navigate services within the community, specifically tailored to their legal needs, with the goal of providing an emotional supportive network. Together, they provide holistic services to victims and survivors of sexual violence. And with that, I will turn it over to this wonderful team and let them take it away.
Thank you. Well, good afternoon, everyone. As Raylene said, my name is Michelina. I am the attorney working under the Legal Assistance for Victims grant. So at Standpoint, we actually represent some victim survivors. And so Rashawn and I work on Title IX processes. So that's what we're going to be talking about today. I'm going to let Rashawn take over the learning objectives.
Yes, so like Michelina said, I am the advocate on the team. There's two of us, but today you only get one. So some learning objectives today is to gain an understanding of Title IX, the Clery Act, defamation laws, OFPs and HROs, and how those work with Title IX, to explore the role of advocates in Title IX proceedings, review when to obtain legal advice or representation for survivors in Title IX processes. Oh no, go back. Hey. A preview. Discuss preparing your client for Title IX investigations and what kind of resources and accommodations they can get, and identify resources for more study in the above areas of Title IX, Clery Act, and defamation.
Yeah. So as you will see in this PowerPoint, this is a very content-heavy PowerPoint. This is not how Rashawn and I would normally create PowerPoints, but what we wanted to do is create something that new advocates or advocates who are working on Title IX, maybe for the first time or the first couple of times, it's something they can print out. Thanks, Raylene, for dropping that. It's something they can print out the PowerPoint and just use as a resource. I want to have, before I even get into what Title IX is, I just want to have a general disclaimer about this PowerPoint. This is not the be-all, end-all answer for Title IX process. This is not the be-all, end-all answer for what the rules are. This PowerPoint is to give an understanding and vocabulary for what you're going to be looking at, what you're going to learn, and give you some resources, some safe resources that you know are going to be reputable to learn more about it and to learn from experts. So that's why this PowerPoint is going to be so content heavy. So with that, what is Title IX? That top quote, that is the federal statute, and it is what most people think of when they hear Title IX, that it is a sex discrimination statute. This helps women play sports, which it does, but Title IX is also a tool that victim survivors can use post-sexual assault, because sexual discrimination also incorporates sexual assault and a harmful environment, and making it unable for a student to go to school because they have been sexually assaulted, or because they're worried about being sexually assaulted or harassed afterwards. So the general rule for Title IX is that if an academic institution receives federal funding, they have to comply with Title IX. This would include private institutions, so think like K through 12 charter schools, or say Hamline University. Various private schools also have to comply with Title IX if they receive federal funding. One thing that is kind of interesting about Title IX is that when it was first enacted in 1972, that was a federal statute that Congress passed. That's what you're seeing at the top. And then the Department of Education came in, took that statute, and they create rules to help implement that statute for the colleges and the K through 12 academic institutions to know what they need to do in order to comply with the federal statute. And then courts come in, they see either the federal statute or they see the Department of Education rule. If it's confusing and there is a lawsuit, then the courts will interpret the rules. So you have rules about what Title IX is coming from each one of the branches of government. This is important because within that, there are also states that will create laws to help interpret what Title IX is for their state, or create laws that mirror Title IX. Minnesota is one of them. We have a statute, and then we also have rules under the Minnesota Department of Education that in many ways mirror the federal statute. The takeaway for that is you don't need to know them all. The Minnesota statutes and any state statutes, they can be more protective. They can't be less protective than Title IX. So with that, we can go to the next slide. So what is Title IX? It's a federal law that prohibits sex discrimination in education. It covers sexual harassment and sexual violence, as I said. That's what we're going to be covering for the most part in this webinar. It basically means that the schools, they're duty bound to respond to and remedy hostile education environments. And if they don't do it, they'll lose federal funding, or they may lose federal funding. Where I've got one instance of sexual violence is enough to qualify as a hostile education environment. That is technically accurate, but as you work in this field, you will find out that what a school determines as a hostile educational environment will really depend on the school and the school's environment. When a school has to respond and how they have to respond depends on the Department of Human Rights regulations. That's why some of you may know the regulations recently changed, and some of those regulations that changed relate to when a school has to respond and how they have to respond. You can usually find Title IX in the student handbook, code of conduct, or the annual security report, which will kind of go over what that even is. So we can go to the next one. So who's covered? Students, faculty, and staff, this is a gender neutral law. So going back to that, what people expect of what this law is, yes, women can play sports. It helps women to play sports, but this is a gender neutral law. And especially when we're looking at responding to sexual violence, that's kind of important to note here. It also is a K through 12 law. And we're not going to go into K through 12 much in this webinar, but I just want to point out that it does also cover K through 12. The K through 12 institutions are less rigorous in how they follow the statutes. Some of the schools can be great, but usually the person who is trying to implement that rule is wearing a lot of hats. So just to be aware that that may not be as easy to know where their policy is, what their policy is, how it plays out. But it does exist. And the Department of Education requires that K through 12 follow it if they receive federal funding. And then this you'll mainly see this in post-secondary and graduate school. And that's what Rashawn and I have, for the most part, worked on when we represent clients on those cases. So new regulations, very exciting. We had old regulations that went into effect in 2020. If you know anything about the field of Title IX, you know that it was a very black day when those regulations came out for victim survivors. There's a lot of regulations there that are not trauma informed. And so the Department of Education on April 19th released new updated regulations that in many ways fix those problems. I'm not gonna teach you all those regulations, but I will give you a link to where to find what those regulations are. So the thing to know about this though is the regulations take effect August 1st of this year. So any sexual assault that happened before August 1st is going to have the old regs apply to it. So you're going to kind of be double dipping and having to use both regulations for a little while. All of us are though. All of this is new for us. And so even the experts, there are some areas that they're not sure. So you're in good company, and you're not going to need to know everything. But that's just something to be aware of. There have been multiple legal challenges. As far as we know, it's still good law. And then basically what the regulations did is it expanded the protections for victim survivors and made them more trauma informed. They did a whole lot more, and I'm not going to get into that, but that's essentially it. So if we want to go to the next slide. So these, I'm gonna go through a couple of regulations, and the takeaway here is not to memorize what these regulations are. What I'm doing with these regulations is to give you an idea of what the new regulations look like as opposed to the old regulations, so that you can get an idea of the atmosphere that you're dealing with, the political atmosphere and the expectations for victim survivors when they're going through this process. And again, at the end of this PowerPoint, I have a resource that you can go to that it's this lovely webinar put on by experts going through all of the new regs. So like, don't worry about this. This is just kind of getting that 20,000 foot view of just what you're dealing with. So the first one, it clarified this regulation clarifying that Title IX, the federal regulations control. If a state law has more protections, if a state law has less protections, if there's any conflict between the state, or in this case, FERPA, so the Family Education Rights and Privacy Act, if there's any conflict between those laws and Title IX controls. And that that's not really new. The general understanding in legal analysis is that the federal law will control. Not all the time, there are some exceptions, we won't get into that. But the general understanding is that the federal rule controls. But this, some of these regulations put on the books things that should be assumed, but we're not going to assume it because we don't want to have that argument. And then discrimination. So they clarified, they put on the books exactly what fit under what was sexual discrimination. It included discrimination based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. Again, if you've been working in this field, or if you're new to this field, just what qualifies as sex discrimination, what definitions qualify as sex discrimination are constantly being argued legally. And so to put this affirmatively into the regulation is very important because again, it prevents victim survivors from having to argue that the discrimination that they experienced even qualifies. Then for the scope of discrimination, the new regulations put on the, expanded the scope of discrimination, expanded the scope of what is considered protected under Title IX. One of the things that they added was the theory of a hostile environment. So if the victim survivor is experiencing a hostile environment in their education, and that can include things that occur overseas. So if they're doing school online, if they're experiencing a hostile environment, that can qualify under Title IX as sexual discrimination. We know it happens. We know that abusers use that all the time. It's just one additional way to control people. But before these regulations, before April 2024, the hostile environment was not in the regulations. So that is not going to be protected for anyone before August 1st, 2024. So we can go to the next one. Thank you. So the oops.
No.
We're just showing everybody all the new slides. Okay, cool. So again, the application for Title IX, this is where what I had spoken about before. When a school has to respond and how they have to respond, this is the regulation 106.11 is the regulation that sets out how a school is supposed to respond. So before 2024, the school had to have, quote, actual knowledge, unquote, of the sexual harassment. And depending on what school you're at, they may define what actual knowledge looks like, or they may apply it differently, depending on their understanding of sexual violence in the school. And then also, once they had that actual knowledge, they had to respond promptly in a manner that is, quote, not deliberately indifferent, unquote, which, what does that even mean? Which it gave a lot of leeway for schools on how they were going to respond. This rule is much more controlling. It tells the schools how they're supposed to respond in a way that is going to be more protective and more trauma-informed for the victim survivor. Then another thing that was changed in 2024 was the complaint. Prior to 2024, there had to be a written complaint. There were very specific rules about what needed to be in that complaint for it to qualify as a complaint. This particularly was important for K through 12, but it also definitely was an issue in undergrad as well. So it needed to be in writing, it needed to have a specific format, and the students needed to be currently participating in school or attempting to participate in school. If they left, like if they graduated, they couldn't bring a complaint. The new regulations changed that. Not only did they make it, did they put some language saying that it needs to be the requests that objectively can be understood as request, but they're saying it can be oral. They're making it much easier for a victim survivor to access Title IX supports, and if Title IX moves forward with an investigation as well. And then it also changed so a victim survivor can wait until after they have graduated before bringing the complaint. Again, caveat, these regulations do not go into effect until August 1st. But so those regulations, that's kind of the change in the environment. And then finally, live hearings. This is something that in the 2020 regs, it has caused a lot of trauma for many students. We've seen certain students who just don't want to move forward with the hearing or the process because this live hearing requires that the abuser can have an advocate of their choosing. So it could be their parent, it could be their coach, it could be their friend if they're like on a sports team, they could have their friend come in, and that advocate is then questioning the victim survivor. So this is not an attorney asking them, this is just some random person, which understandably is very traumatizing for a victim survivor. But under the 2020 regulations, a live hearing is required. Under the 2024 regulations, schools don't have to have a live hearing. They can, but they don't have to have a live hearing, but they do need to create some process so that the victim survivor and the abuser can ask each other questions, not necessarily in live hearing. One thing that it could look like is the abuser asking, like writing up some questions, sending them to the investigator who's doing the Title IX investigation. And then the investigator asks those questions. So this is one that's going to come down to what the school's environment is. Some schools are going to see that new regulation and are going to change their policy immediately. Some schools are not. So that's something to just kind of be aware of. And then, so those are just a few examples of what the regulations are. This is a non-exhaustive list. There are a lot of regulations. This is just to get an idea of the difference in the environment of what you're going to be looking at when you're helping a victim survivor navigate Title IX or just post-sexual assault in the school setting. Like I said, I've got that video that I'm going to link at the end of this presentation, and it's like a half an hour video from the Victim Rights Law Center. It's excellent, going through the regulations and how they differ. So I highly recommend looking at that after this. We can jump to the next one.
So some considerations for survivors entering Title IX. It can be a traumatic process. Obviously, it really depends on the school because, like Michelina had said, some can now do live hearings, some are not going to. But it can be very traumatic because it's a third-party person that's doing these interviews, and oftentimes it's multiple interviews. You have to go over they'll type up the interview, and then the survivor has to read through that. They have to read the abuser's statement, maybe some other witnesses. It's a lot. It's a lot for someone to have to, and oftentimes they get the recordings of those interviews, things like that. It can just be really traumatizing. I know sometimes in the past, at least, I've had people who had multiple interviews and they had to tell the sexual assault story like 3 or 4 times. And I'm not saying that happens every time, but it really just depends because that the person interviewing is a third party, oftentimes someone that's not trauma informed. We have definitely had ones that were definitely, or at least I felt like they were trauma informed. But you just don't know what you're going to get. And I think especially depending on where you're an advocate, asking people, asking other advocates around you or other agencies that might also work in the same area as you, if you have that option, or if you have a connection to someone in the school or whatever you can do, sometimes that can be helpful to see like what their experience has been. So that's just something to potentially think about. And like Nicolene had said, you're confronted by, it could be anybody. It could be someone that you thought was your friend at one point and now they're the advocate for your abuser. It could be like a coach, a teacher you might have to see again. It could be really anybody. So that adds a lot of anxiety as well. And just in general, I think the process is a lot longer than people ultimately think that it is, because they have to do all of those interviews. And then timeline wise too, is a lot of, at least in our case, most of the people that we've worked with are currently in school. And a lot of the deadlines are quick, like a week, and with homework and everything, it just can be a lot. And I don't think a lot of times people fully know what they're getting into. And this is not to talk anybody out of the process at all. It's more just to give people the opportunity to see what their options are and what may or may not be, they decide ultimately what may or may not be the best route for them. Also, I don't know if I'm saying this part, Michelina, but you can just interrupt me if I'm not.
Yeah. Oh, no. Yeah. I was just going to say also, look, right now, especially looking at this, it looks pretty black. Like the Title IX process looks really traumatizing, which it very much can be. But this is where, if you take nothing from this webinar, I want you to take that Title IX processes and the post-sexual assault process in schools are extremely fact-specific. It depends on the victim survivor. It depends on the school you're dealing with. It just depends on the political environment. It depends on how many witnesses you have. It depends on the county you're in, whether you want to do a harassment restraining order or OFP. It really does depend on all of the resources here. So we're throwing out some ways in which Title IX can be extremely traumatizing. That we have seen it be traumatizing, but it isn't always this, like, it isn't always that process. It always is going to be, always going to be unpleasant. But whether it is intentionally traumatizing or whether it is deliberately putting up barriers for the victim survivor is really going to depend on the school.
Yeah, and ultimately with most processes, like the criminal process, sometimes protective orders, depending on the situation, like if you're going to evidentiary, all of those processes can also be very traumatic. But I think this is one that at least before I started working with people that were going through the Title IX process, I didn't know about the multiple interviews or the third party that's going to be potentially the abuser's advocate of choice, all of those things. So it's really just about like laying it out there, because all of these processes need work. And you know, the one good thing is that a lot of the regulations that were really traumatic have changed. So that's a good thing.
Yeah. And so another thing that could be traumatic is it is possible, there is an argument that the information from these hearings or from this interview from the hearing, there's only one hearing typically, but the information from the interviews from the hearing could be used in a criminal case. We have not seen that. In our cases, we've not seen that, and hopefully we never do, because it would be horrible. There is an argument, and I'll go into like why this is, but there's a really good argument as to why that information should not be allowed in a criminal case. But it's possible that it could be. So going into that, the Title IX processes, they kind of look like and they kind of sound like they're a judicial process. They use terms that look like it's a legal process. In the loosest of senses, it is a legal process. You have to follow the laws. There is a written rules that you're going through. There's the hearing at the end, but this is not a judicial process. This is not a judge that is evaluating the evidence. This is not law enforcement who is investigating. These are random third parties. Some of them have various levels of education on how to investigate, who are investigating what happened. The individuals who hold that hearing are usually people who work at the school, and then maybe an attorney who they pull in to handle those hearings. And the rules of evidence, depending on the school, may or may not apply. The rules of evidence are a tool that the judiciary uses to prevent someone from bringing in evidence that is extremely traumatizing and is not relevant. But that doesn't exist in the Title IX process. So that's kind of a double-edged sword. Obviously, it can make a Title IX process more traumatizing, but because it's not a judicial process, there's an argument that it shouldn't be allowed in the criminal court. That is a judicial process. We have seen, though, nationally, not personally, Rashawn and I have not had this in our case, but nationally, there was a very famous case that did use the Title IX investigation, the contents of the Title IX investigation in a civil lawsuit, in a defamation lawsuit. I'll talk about it later, but just to know that that is another way that this can bring up a lot of additional anxieties for victim survivors when they're deciding whether they want to navigate through this process.
Okay, so some resources and accommodations. So Michelina had put up there about, like, as part of the regulations, a victim survivor does not need to file a formal complaint to get some supportive measures. And I think a lot of the times that's the one that we tend to go with, because that's the one that the survivor wants to do more, because you don't really have to do much other than reach out to your school. Oftentimes I tell people just to reach out to their what's the name of them, the people they meet with for your schedule and things.
Academic advisor.
Yes, with your advisor, because oftentimes schools do it very differently. So like you could also reach out to the Title IX coordinator as well, but I find that it's easiest to just do it through someone that you already have met with and that you somewhat know. And you can, obviously, an advocate can be at those meetings. And there's a bunch of different ways that you can find ways to make the survivor feel safe. And I know, even in like protective orders and things, like there are constantly ways in which we as advocates are looking for creative ways for someone to feel safer. And in this situation, oftentimes, not always, but oftentimes the abuser is probably on campus, maybe on your same floor of your dorm, things like that. So you can use some of these like accommodations through your school to potentially move dorms. That's a common one that we've had people do. If you're doing like work study through the school, potentially maybe switching work study to something that's either less people facing, just in case, so you don't have to worry about running into that person. Or if it's like in the building that they're in, like let's say they're in the business building and that's where your work study is, but you don't normally go to that building, maybe potentially switching for that reason. Changing schedules, and that's same thing for K through 12 as well. I think a lot of times we're finding ways in which making sure they're not together, passing times, seeing if they can have, and this is more for K through 12, because passing times are a big thing, but seeing if they can get like a laminated pass, so at any point they can leave the room like 10 minutes early to go to their next class, or they can go to like a safe place, which is oftentimes like an advisor's room, or sometimes people have like rooms that they just like let people go into, that are specific. So those are always an option. Obviously, passing times is less of a thing in college. There's obviously passing times, but it's just very different. A security escort, that can sometimes be an option. I mean, it's not oftentimes an everyday option, but it can be an option for certain things like bigger events and things like that, like a football game. Deadline extensions, oftentimes victim survivors are struggling to get their homework done, to go to class, to do really anything, because they just went through a very traumatic experience and they're dealing with a lot. So deadline extensions are a big one. They do have to disclose somewhat, like they don't have to go into in-depth what happened to them, but they do have to disclose that they were sexually assaulted, and if they're wanting like specific accommodations because of another individual, like moving dorms, they may have to say the name of the abuser. But for like things like deadline extensions, I've had it where they didn't have to say who it was. But it's just something to keep in mind. Like I said, they don't have to give details. Course related adjustments, same thing, as like getting deadlines and like for tests and all that kind of stuff. Counseling, obviously. And then sometimes you can get like increased security around a specific area. Like if you're, again, at a dorm, or if you're doing something specific that you have to be at that you're scared because you have to leave at like 10 p.m. after a exam. Again, that one really depends on the security, how big the school is, things like that. I think the common ones are being able to like change dorms, or getting deadline extensions and things like that. You can really ultimately be pretty creative. The worst the school can do is say no. And I find, especially with K through 12, the more creative, the better, because everyone is concerned about taking away the right of the other student to education and a lawsuit from them. But they also want to make sure that the other person also feels safe most of the time. So just about being creative in what would make sense for the victim and survivor. And sometimes that might be some, very out there accommodation that really fits their need, and they will know the best. And obviously, like I said, schools really differ, and it will really just depend on the school. So I would definitely plug into whatever area you're in, and whatever people are interacting with that school, and see their experiences and go from there. So the investigation. So like I had said earlier, oftentimes the victim survivor is speaking to the investigator multiple times. That really depends on the investigator and like what they need. But this victim survivor can have someone with them. A lot of times, at least in our experience, the last couple of years, it's been over Zoom. I think like our post-COVID world, that's just kind of how it's been, even as recent as like 6 months ago. It was over Zoom. So in that, an advocate can be a support for the victim survivor, very similar to how you would in like a police interview, as like a silent support. Someone obviously able to like advocate for breaks and all of that kind of stuff, because like I said, it can be really invasive, and depending on the interviewer's questions and skills, they might ask really blunt questions that sound very victim blamey, and that can be a lot for someone. So having that added person can be really helpful. I also have a lot of people that I've worked with have said that they oftentimes black out at these interviews. So it's good to have like the recording, even though it's traumatic, because it can be hours of the interview, similar to a police interview. And then the hearing, so like we had said, the advocate of choice, for the abuser, but also for the victim survivor. Doesn't have to be a legal person. And I know it's been discouraged for it to be a legal advocate due to confidentiality reasons. But it's someone who oftentimes has experience doing Title IX, and you don't have to, but I mean, it can be helpful to have that information. An attorney, there are some, I have heard, I have not met them, but I've heard there are some attorneys that do some pro bono Title IX help. I know at St. Thomas there is for sure. And, you know, like Michaelina had already said, the advocate of choice is the one who asks the questions to the abusers and the witnesses potentially. And they can do openings and closings for the hearing, or also the victim survivor can as well. Again, it really depends on the school, and it also depends on, like, a lot of times they just leave it up to the victim survivor and what they want to do. So yeah.
And then after that hearing, after the either it's an individual or it's a panel, depending on the school, depending on their process, after they've made a decision, if it's a not great decision, then the victim survivor has to decide whether or not they want to appeal. So when they're thinking about whether or not they want to appeal, there are a couple things that they want to be thinking through. And one of the big things was there some sort of procedural irregularity in the process, in the hearing process, particularly, that harmed the victim survivor's ability to show that they were sexually assaulted or sexually discriminated against. When we're talking about a procedural irregularity, we're talking something big. We're talking something like the abuser was able to give a closing argument, but they didn't allow the victim survivor to. Or the victim survivor, you've got a hearing via Zoom or a hearing that is scheduled, and the victim survivor lets the organizers know that they're having technical difficulties or they're going to be late, like 5 minutes late, and they start the hearing without them. And so like the victim survivor doesn't get in until 2/4 of the way through the hearing. That would be an example of a procedural irregularity. Frankly, if they started without the person. All of this, again, is going to be fact dependent. But that's an example of something that would be a big red flag of something that could be appealable. Another thing that if there is that procedural irregularity, they also need to show that there may have been a different decision made if the person was able to be at that close and to give that closing, or where you're able to be there at the beginning of that hearing. So they need to show that it very well may have been different. And then another big thing that the fact finders have to do is they need to support what their finding is. So if they make a decision, they have to show their work, just like in math. If they don't show their work, then that could be a reason to appeal. Or if, as they're working through their analysis and their findings that they're making, if the finding that they're making, if their decision that they're making is completely unreasonable based on what the evidence is, and the fact finder doesn't explain why they're not following this evidence that clearly conflicts with what their finding is, that could be a reason for appeal. Again, very fact dependent. If you have any questions about like whether this would apply or not, that would be a great reason to reach out to Standpoint and just kind of talk through what you're seeing, because this really is going to be fact dependent. We can go to the next one. So now we're going to dive into defamation laws. So we've stopped talking about Title IX, and we're jumping into a different body of law. We're talking about defamation law because it comes up a lot in post-sexual assaults. and it comes up particularly in Title IX. So there are a couple, you do not need to read this wall of text. There are a couple different definitions of defamation. The first one is your civil law, civil court definition of defamation. The second one, the Minnesota Statute 609.765, is criminal defamation. So if someone commits defamation by this definition, then they could be criminally charged. And then the bottom, or the Canaan v. Yale University, is that civil case that I had mentioned earlier. We'll go over all of these. So defamation per se, it's a statement that's clearly injurious to the person who is the object of the statement. So the clearly injurious to the abuser. The primary form of defamation per se, which is Latin, because we are in law and that's what we do. So the primary form of defamation per se is a statement that a person has committed a crime, particularly a crime of moral turpitude, i.e. sexual assault. So oftentimes, if a victim survivor is saying that they were sexually assaulted, or if one of their friends says that their friend, and they name their friend, was sexually assaulted by this person, or in some way identifying them, that is defamation. If someone else hears it, if someone else shares it, what that person said, either the victim survivor or the friend, if that's shared, it's defamation. And they could be facing a civil lawsuit. Now, the truth is a defense. It will always be a defense. So they might say that they are sexually assaulted. The fact that they are sexually assaulted means that it's not defamation, but it could open a victim survivor up to being having a lawsuit filed against them. Criminal defamation is very similar. I'm not going to go through the definition, but it's the same theory, and you have it there. Canaan v. Yale University was a civil defamation lawsuit. That was a defamation lawsuit where the victim survivor was going through a Title IX process, and the school may or may not have violated the abuser's academic rights and their Title IX rights. We're not going to get into that, but the school made a decision, and then the abuser or the student who was the alleged abuser was filed a lawsuit against Yale University as well as the victim survivor, claiming that they were defaming that person, defaming the student. They pulled from it the Title IX, the information from the Title IX process, including the information that the victim survivor said. This is it's a very scary lawsuit, the fact that it even happened. What the court determined was that statements made in a Title IX hearing may open up the victim survivor to having a defamation lawsuit brought against them. However, and this is a big however, this is very important, the abuser has to show that the victim survivor acted with actual malice. Now, actual malice, it's not just they made a mistake. They had to have acted with actual knowledge that what they said was false, or recklessly disregarded whether it was true or false. So the abuser needs to show that first before the Title IX information before they can file a defamation lawsuit based on what the victim survivor said. But it still is a very scary lawsuit, because we thought that, or the attorneys of the U.S. thought that a victim survivor would be protected when they brought that complaint. And usually they are. Usually they're going to be fine. It's just when we're looking at the defamation landscape, that's something that we're starting to notice, that abusers are using defamation lawsuits sometimes to try and control people additionally. But really the biggest thing, the takeaway from defamation law is that the most important thing is the abuser identifiable? If they can be identified based on either the person throws in their name and identifies them by name, or identifies them by context. So like an example of that would be, I was sexually assaulted by a pilot on my Delta flight, and they list the number of the Delta flight. There are only so many pilots on that Delta flight. It's clear based on the context that it's one of these people. So that would be a very risky statement to make. However, it wouldn't be a risky statement to say something like, I was sexually assaulted at the airport, or I was sexually assaulted when I on my flight, or on a flight, unless the person has only been on one flight in their life. Again, it's going to be fact dependent and what that context is, but the most important thing is this abuser identifiable? That's going to open the person up to more or less risk of defamation. So we can jump to the next one. So in looking at this, when you're assessing defamation, and I just want to throw out here, this is an area that can be very complex. If this is an area that the victim survivor absolutely should talk to an attorney before they're, if at all possible, I would advise them speak to an attorney before they post something online and before they start talking to people. Because it's going to be fact dependent. It's going to be, and it could just provide some security for the person before they say something. So as we go through this is not going to be the end of the legal analysis. It's going to depend on the facts of your specific victim survivor's case. But generally, when we're looking at the risks, a risk analysis, we're looking at how broad is the circle of confidence? How many people are you talking to? And how are you talking to them? Like, what's the forum? Are you talking to them in person? Are you posting on Facebook? Are you posting on Twitter or Instagram or some other online communication format? Based on, like, if you're only speaking to your childhood best friend that both of you you trust each other implicitly, that's a very different scenario than posting on a victim survivor forum on Facebook, which can be those forums can be incredibly nurturing and validating, and really good things can happen in those forums. But you don't know everyone in those forums. You don't know everyone who's following you on Instagram or on Facebook all the time. I mean, maybe sometimes you do, but all it takes is for one person to share what you said, and then you could open yourself up to defamation. So that it gets much more risky the more people you're talking to. And then if you have assets, or if the victim survivor has assets, that makes it much more risky to make a statement. If you're a random college student who is driving a beater, it's going to be hard for them to, it's going to be hard for the abuser to win on any defamation lawsuit. Defamation lawsuits cost a lot. They're a lot of money. You have to hire an attorney, and all of the legal costs are not cheap. So they're looking for someone where they can get money from them. You can't bleed a stone. And so that's another thing to think about. Does the victim survivor have assets that they could, that the abuser could get at if they file a defamation lawsuit?
Yeah.
And then, oh, go ahead, Rashawn.
Oh, I was just gonna, and how advocates can help. So
Mhm.
obviously all of this depends on capacity, and I feel like for most of us, the capacity is not a lot. But one way in which I've helped clients when it comes to attempting to find representation for any kind of tort case. So anytime either they want to sue their abuser or an institution, or I haven't had to do this yet, but if someone else was suing them for defamation, same thing, is I help them create a timeline. Because oftentimes when you're looking for representation for any kind of tort case or employment case, whatever it is, they ask you on the phone, tell me like what's happened. And I think for a lot of victim survivors, they think of what's at the top of their mind, what stands out like the most for them, what was the most traumatic, like things like that. But an attorney is looking for like the whole picture and like the breakdown in like a very numerical way of like this happened, then this happened, then this happened. And I think it, at least when I've helped survivors make those timelines, I think it's been very helpful. They can send that usually via email to one of the attorneys instead of having to do like multiple phone calls and tell the story over the phone over and over, which is traumatic. They have this one document that they can send, and if that law firm can't take their case for whatever reason, then they can send it to the next, and all of that obviously is confidential. So, and sometimes it does take quite a bit of like shopping is probably not the best word to say it, but like just reaching out
And
to
also
multiple.
finding an
Yeah,
attorney who will take your case, but also you feel comfortable with that,
right,
which is
exactly. Yeah.
equally important.
So that's basically what you're doing, and having that, and usually I would say like a page to 2 pages as much as you can, because the longer the document, the more I think things get lost. And what I've heard from other attorneys that we've sent these timelines to is that like a page is what is the sweet spot, but if you have a lot more information, that's fine too, because it's just a real rough overview of like the harm that's been done and like what meets the statute for like defamation, or to be able to sue them for money, whatever it is. That's what they're looking for. So, and then obviously they'll suss it out more as they go on if they do take the case. And then obviously if you have any questions about defamation, or if you're with a client and you're like, do they qualify, or same thing with like employment law and torts and all of those things, just you can always reach out to Standpoint with your client, or get your client's permission to reach out and ask more questions about that.
Yeah, because again, like this defamation, it is a complex area of law. I distilled that down into just a couple of slides. Defamation should not be distilled down into a couple of slides because it is very complex. But again, this webinar is not to teach you, by the end of this webinar, you will know all about the Clery Act and Title IX and defamation. No, this is not what this webinar is for. This webinar is to give you the large bodies of law that you're going to be dealing with that are different than your standard criminal procedure, civil lawsuit, HRO, OFP, legal process. So if you have any questions about this, or if as you're working with your clients, you're realizing that you don't actually know what the answer is, or you're not positive what the answer is, call Standpoint. That's the reason why we're here. So with that, we're gonna jump into the last body of law that you're probably not familiar with, and that is the Clery Act. This is another federal statute. It was enacted in 1990. This only applies to higher education, so this is not K through 12. But this is a consumer protection law. It's focusing on transparency. After Jeannie Howard was murdered, her parents lobbied and got this law passed to ensure that colleges were we're being transparent and telling students about the crime on campus and the policies for how the school handled crime, and providing supports for victims and victim survivors, and sexual assault situations, but in many different areas of crime. So in 2013, the Clery Act was brought in to address additional types of sexual violence, so specifically sexual assault, domestic violence, which would be and I don't know where my notes are. That's helpful. So domestic violence, dating violence, and stalking. And so this would require colleges to report on-campus crimes, and also report the school safety policies, how they're handling the crimes, how they're handling victim survivors, what they can do after they have been victimized on campus. It also requires that schools provide what's called a timely warning of current crimes. And then it applies to on campus, but then it also applies to off campus and associated with institutions. So like an example of that would be you have a swim team for the college, and the college doesn't have a swimming pool, and so their team goes and does practices at an off-site pool. That would be an off-campus associated with the institution example of if crimes happened at that pool. So we can, okay, so thanks, Rashawn. So the main things, because again, the main things to focus on for the Clery Act, because this act is focusing on transparency, there are going to be some overlaps with Title IX, but it's really focused on consumer protection. It's focused on making sure that students know what to expect. They can pre-plan for if something were to happen, they know exactly where to look for the process. So schools are required to provide annual security reports that they release each October. They have to release it each October. It's very easy to determine whether there's been a Clery Act violation because you just look the school up online and see whether they have released their most recent annual security report by October. And if not, well, then you very likely have a Clery Act violation. So they are supposed to report on stalking, intimidation, dating violence. Here's where my notes were. I was wondering. So intimidation, dating violence, domestic violence, which includes where the abuser is a former spouse, a cohabitating partner, or someone who shares a child with the victim survivor. Sexual assault and hate crimes. Those hate crimes would be crimes based on religion, gender identity, sexual orientation, ethnicity, national origin, and disability, whether the person has a disability or whether they are perceived to have a disability. So either one. It's kind of like your standard hate crimes. So they're supposed to release that annually. They're also supposed to release a daily crime log. That's something that they need to update every 2 days. That includes the crimes from that area, unless it would jeopardize an ongoing police investigation. So again, like this is about making sure that students know what crimes are happening. And it can be a useful tool, especially the daily crime log can be a useful tool for a victim survivor if they are living on campus and they're very nervous about like their local area. And so they can look, or you can look at the crime log and the past crime log and like the past trend of crimes in that area to determine whether that area is not objectively safe, but is a safer option to be in. Because if there's a lot of crime happening, maybe it would be a good opportunity to, or maybe it would be a good choice to have the victim survivor move to a different hall or a different apartment, something like that, where it's going to be a little bit more secure for that victim survivor. Big thing about the Clery Act, colleges, they don't need to investigate. So that's different than Title IX, where Title IX needs to respond, provide accommodations, and if they're aware of sexual assault or sexual violence. The colleges also can't release the victim survivor's name or identifying information if the victim survivor was victimized on campus. So we can jump to, so another thing that the Clery Act does is it ensures, again, about transparency. It ensures that the victim survivor knows what accommodations they have at their disposal, what they can do to get supports in school, to access supports off campus. So the school is also supposed to know of local supports that might be useful that they're not providing. They're also the school is also supposed to notify the student of the disciplinary process and how they can report to law enforcement, the fact that they can report to law enforcement, and also wow, that was not grammatically correct. Show them how they can report to law enforcement and access those services. Just like in Title IX, it prohibits retaliation after reporting. That's all types of retaliation. And so kind of a key takeaway for this is, again, this is for higher education. It's about notice. There are many ways that attorneys can use this sometimes to be creative in applying this to a Title IX process, but that's not something that you need to focus on. This is a way that you can find their compliance literally online, literally on their the school's website. And so if you think that there might be a violation, or if you're not sure if there's a violation, or if you're not sure whether the college has to comply with the Clery Act, that would be a reason to contact an attorney. So one of the resources, and we'll have it at the bottom of this or at the end of this presentation, is the Clery Center. And if there is a potential violation, if you're not sure if there's a violation, or if you're not sure if the school has to comply, you can contact the Clery Center and work through that analysis. Because if a school doesn't seem to be complying, that could be a red flag. That could be it could be fine. It could be that the school doesn't have to comply, but it could be a red flag, because if they're supposed to comply, then what else are they not complying with? What else in Title IX are they not complying with? Okay, so.
So when does an advocate's role end and an attorney's role begin? So that, like I had said previously in the presentation, there's a lot that advocates can do, but there is a lot of, weird is a bad word for it, but like, for this sake, weird things about Title IX, and everything we covered today. So if you're not sure if the school is subject to Title IX regulations, especially like things with K through 12, those can be very confusing. The whole Title IX process through K through 12 is very confusing. If, like Michelina said, if you suspect there may be a Clery violation, if the abuser has hired an attorney, if the abuser is threatening legal action against it, especially that one, if they're talking about like defamation, if they're talking about anything like that where they're going to sue the victim survivor, I know that does happen more than it should, the threats for sure. So in that situation, you can totally call Standpoint, or you can consult. There are some attorneys that will take a phone call and give some limited advice. So those are also options too, but you can always call Standpoint with those questions. If you have questions about the victim survivors' rights, if they're being violated, in anything, including criminal, but also Title IX and everything we covered today, if there may, like I said earlier, if there may be a risk of defamation, and just in general, if you have questions, because it is really a lot of this presentation has been it varies, it depends, and you may not know fully, but listen to or look into your resources, things like that. So definitely reach out if you have any questions, because it can be a confusing process. Hopefully it won't be, but if it is, you can always contact us. Okay, so a note about OFPs and HROs, order of protection and harassment restraining orders. So sometimes order of protections and harassment restraining orders can be a less traumatic option for victim survivors. Not always. If it goes to evidentiary, that can be a very traumatic process, because if the other person is not represented, they may be able, or not they definitely can cross-examine the victim survivor. So that's traumatic in itself. You also have to relive it and all of that stuff. So it's still a traumatic process, but it can be, if what the victim survivor is wanting is for that person to stay away and for there to be some restrictions to where they can go, like what's in this slide, like if you're not wanting them to go into a specific dorm because they don't live in that dorm, so they have no reason to go to that dorm. Or I know we put in, and it really depends on the judge, but we put in orders before, like can't go in the nursing building because there was no reason for that person to be in the nursing building. They didn't need to be there. Or I've had it where I had two student athletes, the survivor and obviously the abuser, and in that we put times that each person could be in the gym. And again, it really depends on the judge and if they'll grant those. But sometimes that can be a good way to get some of those things through a protective order instead of doing the Title IX. Because I think a lot of times people feel as though through the Title IX process, the other party, the abuser, will get expelled. And in our experience, that is very, 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 very rare. We've had it where there's findings that they did abuse the person. And even in those situations, they were suspended for a semester or a couple semesters. It's just very rare, and we have not seen it thus far in 4 years, anyone getting expelled. It can definitely happen, which is rare. So I think when a lot of times victim survivors will do the Title IX process and think that that is the end result, and it's not oftentimes what ends up happening. So protective order can be a good option, as well as using those accommodations for figuring out safe places and getting them a schedule that will try to avoid that other person, to give them less opportunities to harass and intimidate the survivor. And if you're wondering, if you're struggling with like what to do, and you have some, like, there's always some complicated situations when it comes to two students that are at the same school. Like we had said this whole time, you can definitely call Standpoint, and we can help you try to find a solution, some wording that might be more likely from a judge to get granted, because it's really about finding a way to make things work the best for the victim survivor, and sometimes that's just some creative language.
Yeah. And while we're talking about this, I just want to throw out the Title IX, or not specifically Title IX, but many schools will have what's called a unilateral no contact order. That's a school process that prevents both parties from having any contact with each other. Basically, the school is just saying, okay, we don't know exactly what's happening. We're going to have neither of you talk to each other. Neither of you guys can interact with each other. If you see the other person in the room, you got to leave. This is really not a great option, because the victim survivor can be penalized if they have any contact with the abuser. And so I would always advise that the victim survivor not sign this unilateral no contact order. If the school is putting it in place, there's only so much control you have over it. But as much as possible, do not have them sign it. That is not a good thing. Have them speak to an attorney. As if there is one in place, then either they can look at removing it, making it not unilateral, or as part of the hearing process, once it gets to that hearing after the investigation, one of the things that can be asked is that it's not a unilateral no contact order, that it is a no contact order that only prohibits the abuser from communicating with and interacting with the victim survivor. This is another way where OFPs and HROs can be a useful tool, because this is focusing on the victim survivor's safety. And OFPs and HROs don't always, they're not always a tool that's going to keep the victim survivor safe. But there's something that can result in the abuser being arrested. That is not the case with a school no contact order. There could be academic repercussions, and they could be removed from certain properties on campus, but it's not going to result in them being charged with a crime like an OFP or like an HRO. So that can be another thing if the victim survivor is really looking at something that's going to keep the abuser away from them, and that the court is enforcing, because again, Title IX is not a judicial process. It looks like it acts like it is not a judicial process. There's no judge there. There is a judge in an OFP and in an HRO. So depending on the county that you're in, depending on the judges that you're dealing with for who handle OFPs and HROs in the county, it might be a better option. It might be a less traumatizing option to move forward with an HRO or an OFP. I can think of cases that we've worked on where the school that we were working with was incredibly traumatizing, and we knew it. And as the victim survivor was going through the process, they were getting very frustrated because it was a traumatizing process. And so we ended up moving forward with a protective order with I think it was an HRO, but it was a protective order through the courts, and the person got a protective order through the courts. And even though the school proceeding was not what the victim survivor maybe wanted it to look like, certainly wasn't what I wanted it to look like, it's still, having that protective order prevented the abuser from having contact with the victim survivor as they were both navigating campus.
And then we have resources. We're not going to go through them all because we only have 10 minutes left anyways. Leave that in case anybody has any questions. But everyone will get the PowerPoint, and all of these are some great resources to look into.
Regarding that Victim Rights Law Center, so that the video that I was talking about that has the updated regulations, it's approximately a half an hour. The Victim Rights Law Center put on that webinar. They have it online in their under their resource library. So this is how you can find it. It is a little intense. They just kind of run through all of the regulations, but it's excellent. And the individuals, the attorneys who are putting it on, have been working nationally on Title IX. And so they have a very strong grasp of how Title IX works and in effect, both at the K through 12 and the undergrad and graduate level.
Okay, so that was it. Do we have any questions? I'm going to stop sharing because our information and easier.
Perfect. I haven't seen any questions come in. Maybe we can wait just a minute or two and see if other folks have questions. Otherwise, thank you both so much for sharing your knowledge and your expertise with us. Title IX is complicated and confusing in so many ways. So it's really nice that you were able to give us an overview and kind of help us point us in the right direction. So appreciate that.
Yeah, absolutely. Yeah, it's not in some ways it can be very straightforward. And I will say, as we were talking through this process, it seems like there are more, I'm not sure how it works, than there are clear answers. That's not always the case. There are sometimes very objectively clear answers, what is the right thing to do, what is not the right thing to do, based on what the regulations say or based on what the school's policy says. Or like if you're doing an OFP or HRO, objectively clear answers of how it should go. But there are some things that are new, and especially a thing to take away is with these new regulations, even the experts at the Victim Rights Law Center, there are things that they don't know how they're going to play out. They have an idea of how it might play out based on things that they've seen, but no one is entirely certain how some of these things are going to play out. And even if we know how the rules should play out, a school may not actually apply them in the way that they should be applying them. And so just like give yourself a little bit of grace as you're going through this process. You may, with your first client or one of your first clients, you'll read through the process that the school has, and then you get to another case and you read through the process and it's a completely different process. That is normal. It's just finding out where, what areas are actually complying with the regulations or not complying with the regulations, and where making sure that the victim survivor knows what they can do and has some agency in this incredibly stressful process.
Perfect. All right, well, thank you both again so much. I didn't see any other questions come in. To any folks that are in the audience, thank you again for being here with us this afternoon. And I think that's everything. So I'm going to end the recording. Thank you all.
Thanks so much.